Hello friends, today we are discussing an important issue relating to one new forum that has been created through amendment and rather a new act, Companies Act 2013, which replaced the old forum, National Company Law Tribunal, and the appellate forum, National Company Law Appellate Tribunal. These are just one new forum which combines a lot of jurisdiction of different forums. Now, some of the original jurisdiction which was earlier exercised by High Court in winding up proceeding and the compromise and arrangement proceeding under the old Act of 1956 and some other civil courts, including the Company Law Board and DRT, these original jurisdictions are now being conferred to that of the new forum, that is the National Company Law Tribunal. And all the original jurisdiction of all these original side forums now being subsumed to that of the National Company Law Tribunal, which is now called as the NCLT. Similarly, some of the appellate jurisdiction of the DRAT, that is the Debt Recovery Appellate Tribunal, and the IFA, which was formed under the SICA, Sikh Industrial Companies Act 1985. These are the two forums which were earlier exercising some appellate jurisdiction, now being subsumed to that of the new appellate forum, that is the National Company Law Appellate Tribunal. These are the two new forums created with an idea to give a one-stop solution with respect to any kind of disputes or differences or litigation pertaining to that of the companies. And accordingly, these new forums, which is now a buzzword in the corporate sector, that perhaps will be the panacea for all these multi-layered dispute forums and multidisciplinary forums, is perhaps will be the game changer for the corporate world now. Earlier, disputes such as winding up, compromise and arrangement, prescribed under the old Act of 1956, were exercised by the High Court or Civil Court. Whereas other nature of disputes like shareholders disputes, operation mismanagements, these disputes were adjudicated by an adjudicating authority, namely Company Law Tribunal. So, the National Company Law Tribunal has taken over the jurisdictional powers of that of the High Court and some of the jurisdictional powers of that of the High Court, Company Court and Company Law Board. By the amendment to this, there are some reciprocal amendments also have been carried out through the Recovery of Debts Due to Banks and Financial Institutions Act 1993, Securitization Act, SARFAESI Act, we call it as a SARFAESI Act 2002. We have also carried out some of the amendments to that of the Partnership Act, then LLP Partnership Act, and there are of course amendment to the Companies Act, and there are other amendments has happened. By virtue of that, the forums such as DRT pertaining to that of the company's insolvency, pertaining to that of the companies are winding up, now will be adjudicated by the National Company Law Tribunal. So, here is a forum given with the idea to cover all aspects of dispute pertaining to that of the companies. Friends, we have structured one course material, a course structure for the National Company Law Tribunal and National Company Law Appellate Tribunal. In order to impart the training for the purpose of acclimatizing the professionals such as company secretary, chartered accountant and cost accountant, who are now authorized, can become the authorized representative to appear before these forums and can argue, which they were not eligible earlier to argue before the High Court. Because some of the jurisdiction of the High Court and the tribunals, they were not entitled, DRT, BIFA, under the SICA, that is Sikh Industrial Company Special Provisions Act of 1985, they were not entitled under law to appear before them and argue for the parties. Now their expertise, experience now being recognized under law, now they are given the right to appear before these forums and argue on behalf of the parties to impart their special skill set on the company law side and technical skill set. So this course is now divided in 5 steps, which is, the first is the concept of grievance redressal. A synopsis, I am giving you just synopsis of the 5 step course structure. One is the concept of the grievance redressal, and this particular course will deal with that of what is the concept of grievance redressal. Second is the client confidence measures, that is critical for the parties to appear who in a representative capacity for the people to enhance and hone up the skill of presentation. How to create the client confidence. For that, this course structure will address. Then the third step of this course structure is developing a finer contours of drafting, because important is, today as we all know, 1.35 billion population of this country and the number of forums in this country are far less. And what is the order of the day is, and in a resource crunch country like us, the burden has to be with that of the practitioners. While an entitlement is given to you, practitioners, it also expects a sense of responsibility that you should be able to assist these forums efficiently and effectively, to be able to get the justice from these forums and expeditiously. That is very, very critical. So therefore, understanding the finer contours of the drafting is extremely critical. And the third step is the finer nuances of the appearance before these forums and the presentations. Because after all, when you appear before these forums and then make your presentation, it not only deal with that of the facts of each case, it also should be able to tell the surrounding legal questions, the covered legal questions based on those facts. So presentation is a critical, the appearance is a critical. How do you appear? What will be your attire? How your body language should be? How effectively you answer the questions? You should be knowing every aspects of possible questions that may follow from that of the forum. And in order to understand this, after these studies, after all these courses are completed of 4 steps, the 5th step is a very critical, which will enable you to identify your strengths and weaknesses and hone up the skill of presentation through a simulated moot court environment. And that is how this entire course is now devised, to deal with that of your entire skill set to be able to appear and argue. Now the concept of the grievance redressal, as we all know, and in my earlier slide I have already shown to you, that these are the forums created with the idea to expedite the redressal mechanism. And therefore, important to note that the CPC provisions, Civil Procedure Code provisions, are not attracted towards these proceedings, and these proceedings are not bound by that. What is these proceedings are supposed to follow is the principle of natural justice, and therefore the concept of grievance redressal is an important facet to begin with, to hone up the skill to appear and present. And therefore one should understand the concepts of and the meaning of the jurisprudence, that is the justice redressal, the grievance redressal mechanism, the justice redressal forum, the concept of the hierarchy provided under the statute to bring about or to weed out any anomaly in the system. Because what happens in an original forum, one error happens, then you go to the appellate forum, then the appellate forum, you address that particular forum error and then get that justice for you. Because despite all your best efforts, it may so happen that some issues may have lost sight of the forum's final decision. Then you address that precisely on that issue and go to that of the appellate forum. And similarly, even wrong appreciation of the facts also can be agitated in that of the appellate forum. That is how you have to understand the concept of the screening mechanism, the entire system of appellate jurisdictions. Then, what is grievance? Whether it is redressable or non-redressable. There are instances where a particular grievance is, there may be a possibility of grievances, but it is unredressable. For example, sun rises in the east. It's a known phenomenon. You have constructed your house, and the house has a window or an opening on the east side, and the sunlight is entering into your home and causing disturbances. I'm just giving a small example. Possibly there is a grievance out of that, but it is non-redressable. Nobody on earth, because it's not a man-made phenomenon, that you can change it. So there are even certain instances where the grievances may be existing, but it is unredressable. And that is where the human limitations comes into play. So in the grievance redressal mechanism, you should note what are the grievances, identify the grievances, and try to redress them only by approaching the forum, and that forum must be the NCLT or NCLT. Now, as we all know that the dispute which can be adjudicatable by the tribunal and the appellate tribunal pertains to that of the company, the locus plays an important role. Why? Because company is always an artificial entity and firm is always an artificial entity. The disputes pertaining to this will be adjudicated by the tribunal and the appellate tribunal. And locus plays an important role on that. That whether a person has the locus to approach that of the tribunal and appellate tribunal with respect to the disputes. What is the nature of disputes? Whether it is, what kind of relief he is asking, against whom he is asking for relief. If that against whom, say for example, if it is against a company, then whether that company has anything to do with that of your grievances, and whether that particular company can give the relief, desired relief, sought from that of the tribunal and appellate tribunal. These are the issues. So therefore, locus plays an important role. Similarly, the cause of action, a concept of cause of action, that is, what particular action which gave rise to that of the grievances, and thus a person should approach to that of the tribunal. So, concept of cause of action is also plays an important role. Jurisdiction also plays an important role. That is, as we all know, depending upon the location of the registered office of the companies and the firm, the jurisdiction of that of the tribunal will be decided. So accordingly, they will have a territorial jurisdiction. So the concept of the territorial jurisdiction should be properly understood. And provisions of CPC will not be immune from it. For example, from section 15 to 21, which deals with that of the jurisdiction, has to come into play, even if the proceedings before the tribunal and appellate tribunal will not be bound by the CPC provisions. But then these are the provisions will keep coming and will have applications, because we have gone through several tribunals. We have in India, there are numerous tribunals are operating, and all these tribunals, from time to time, even if the statute prescribes the provision saying that the CPC will have no applications, but the principles of law governing from that, this concept of jurisdiction, locus, jurisprudence, grievances, they have to be borrowed from that of the established rule of law, decided through catenary decisions from that of the court, apex courts, including high courts. Limitation, as we all know, provisions of limitation will have application to that of the Companies Act 2013, and therefore the Limitation Act will have its applications, and the principles tested, tried, adjudicated by forums after forums will have all its applications. So therefore the concept of limitation should be understood properly. Now the question of also again res judicata. For example, a particular dispute between two parties, which in fact the concept of the res judicata flows from that of the section 11 of that of the CPC. So therefore that concept of law will always have its application. So therefore one cannot say that the CPC will not have application. Therefore these principles are essential and will have its application, and this is where the responsibility lies of the EU practitioners to not only hone up the skill of law but also its applications. Now we'll go to the next page. Client confidence measures. Friends, it is essential that in order to practice, you have to first, because this is a added power to you, a responsibility. I call it as a responsibility. It's not a power, it's a responsibility. A statute, the nation has given a responsibility to you, and now you have to discharge that responsibility. Now, you can only do that when you will be able to gain that confidence, not only from that of the forum, being an officer of the forum, but also from that of your clients. You should be able to give them enough confidence that now you have the ability to address issues. So therefore, how do you do that? Prepare, according to our module, we will demonstrate how it will help you in enhancing the confidence measure with that of your clients. Because after all, the agreed party who will appear before the forum through you has to repose confidence on you. So therefore, prepare an exhaustive list of dates from the record. The moment you receive that record, prepare an exhaustive list of dates. Small, brief, to the point, to be able to connect to the sequence of events in chronological order, to understand the entire contours of the facts. That's first. And it is important that from that only you will be able to understand the entire contours of the facts and get these entire understanding of facts not only from this list of dates from the records, but also by elucidating your conversation with your clients. And understanding and grasping the foundational law and the subject is extremely critical. For example, even if you know the company law, you will have to deal with that of the succession, Negotiable Instrument Act. You have to deal with that of many of the corporate disputes. So the law governing those facts will create a clarity within you to be able to give a confidence, which will in turn repose confidence on you. That's very important. And always remember, while creating a list of dates, you should pick up the material facts, because after all these facts are there for your grasping of the entire facts. But those critical facts which will deal with that of the cause of action, the locus, the jurisdictions, and the concept of redressal and the relief. And therefore these are critical facts, we have to note it down. And then dotting all those facts, create your own story to be able to present it in a concise form, because as we all know, we will have a lesser time to that to appear before the court and to make a presentation, because there will be so many people waiting in the wing to get it redressed. Therefore, it is important that you give those material facts to that of the forum, which will be able to give you the insights of the entire background of your grievances and the redressal. Then remember always that you are approaching a forum based upon a right and liability. Therefore, understanding the rights and liability will be critical and key to reach to that of the ultimate outcome of your adjudication. Then you have to take a decision also, whether a particular grievance of a party is a genuine or not. If it is genuine grievance, then whether it is redressable or not. And if it is so, then before which forum and when. These are the critical aspects. We will analyze all these critical aspects in our friends. Drafting is the most important aspects of discharging your responsibility towards the forum. And the second important aspect is the presentation. First, as I told you, that you should, in the first step, you should understand the concept of a grievance redressal. Second is elucidate facts from your client, put it in concise form, and then that putting it in the concise form, in the presentable form, is the most critical and will decide the fate of the outcome of the proceeding. And this will also go a long way to decide whether the disposal of the redressal mechanism will be helpful or not, whether it will be expedited or not. So therefore, most of your responsibility will go a long way to achieve the desired objective of the statute, to expeditiously dispose of all these proceedings within a period of 3 months. While you draft your precise drafting, should remember that what are the contours of this entire drafting. One is a memo parties, which is based on the cause of action, which is based on the locus, which is based on the jurisdiction. Then what will be the prayer? Then what will be the limitation? What is jurisdiction? What is the cause of action? What is locus? And relief-centric legal submissions, because concise is the key to achieve the desired objective of getting it redressed at the earliest and the most efficient and effective manner. Then annex the relevant documents which are of relevant only for that purpose of relief, because you have to go bottom down. Relief is important. Keeping the facts of relief, then go up, and the legal submissions also be relief centric. All your submissions should be relief centric. And also prepare a written note with small list of dates to give a bird's eye view of the entire facts. That will be your key to address these issues, and which we will help you in achieving that objective, and it will be a personalized approach. We'll deal with it. Then the fourth one is the fourth step is the finer nuances of appearance, because at the end of the day, while the drafting plays an important role, the other side is the appearance. That will be extremely critical for you to achieve the desired objective. And appearance, you should be completely spick and span with your appearance, your attire, and then your presentation with your written note, and make yourself counted with those relevant facts. That is critical. And here the key lies is the confidence, and the confidence is borrowed from the facts and the law that you know with respect to that particular dispute between the parties. And prepare that written note and go and argue precisely on those points. Avoid grandiloquence, repetition, avoid making submissions on irrelevant issues, and pick up the strongest point at first and the weakest at the later. First, have the confidence on the submissions that you are making, that these are the facts which I should present it first, and the law. It is important that the last, when we will sum up your training program in 4 important stages, giving maximum importance to drafting and the presentation and appearance, we will also test your achievement of the skill set in the training through a simulated moot court compilation. And by your active participation in the involvement of the extremely competent and reputed people in the field of practice from law side, it will not only identify your weaknesses, it will make efforts to improve them, and it will suggest the ways to tackle this problem. Because even though these forums are giving you opportunity, that opportunity comes with a price, and the price should be discharging your responsibility, as I told you. And that cannot be achieved unless you improve yourself, prepare yourself, and get ready for the challenge. Thank you.